insurance or enter into the SPLA program. And we'll talk through some of the differences in how to evaluate which one might be a better solution for your use cases. For those of you who are in the hosting business and like to leverage your customers' pre-existing purchases of Microsoft licensing as part of your solution, we're going to be talking about the rules around bring your own license models and how they can be implemented and what you should be worried about in connection with service offerings that leverage your client's own licenses. Next, we'll talk about policies and procedures for those who have adopted a SPLA program. How do you set them up correctly so that you're reporting on a monthly basis accurately, and when and if you're audited by Microsoft under your SPLA agreement, you'll be prepared to respond in an efficient way that will easily demonstrate that you've been complying with the terms and conditions of the agreement. But what about your customer contract? Is there anything that you need in your customer contract as a hosting provider or a cloud provider to include by virtue of the fact that you've now entered into or subject to the SPLA agreement, which in the SPLA agreement with Microsoft, there's a section that specifically designates the terms and conditions that must be included in your customer contract. So we're frequently working with our clients that are in the SPLA program to make amendments to their customer-facing contract to comply with that provision. And then 6, what reporting tools should I use to manage my commercial hosting environment? And we'll go through the tools that auditors use and the data that auditors will be looking for, and talk you through some free tools that you could be using to more effectively manage your commercial hosting environment and to make sure that when the time comes, you'll be ready to respond to an audit with the appropriate data. Do I need commercial hosting rights? Well, as I mentioned, the product use rights for retail and other OEM agreements include the following. You may not host the products for commercial hosting services, but no Microsoft agreement specifically defines what constitutes commercial hosting services. So you have an interpretive challenge on your hand to evaluate whether or not your use cases are within the scope of this prohibition or are not constituting commercial hosting and therefore within the original license grant. There are 2 resources Microsoft has published that we generally use when counseling clients on these issues that will help you evaluate your server use cases in order to determine whether commercial hosting rights are required. Those documents are the Service Provider License Agreement Qualifications Roadmap and the Service Provider License Agreement Program Reference Card. The Service Provider License Agreement was published previously. Years ago, we started using it to help clients evaluate their use cases. As far as we know, it's no longer available through the Microsoft website, and the SPLA Program Reference Card is the newest guidance that is currently available on Microsoft's website. I don't think that either of these documents leads to a wildly different conclusion on the question of whether or not someone has a use case that's running afoul of the commercial hosting prohibition, but it is interesting, I think, to look at both because the formats are somewhat different and there are some differences. One thing I've always liked about the roadmap was that it was a sort of ask a question and then based on the answer go to a different box. So it made it very, very easy for us to, when talking to clients, understand in relevant terms the nature of their commercial hosting operations. And one of the questions which is pictured on this slide, the determinative issue often came down when we were looking at these use cases and applying the roadmap, was this question number 5. is the third party using the software application as a way to acquire goods or services from the licensee? If the answer to that question is yes, you may be on the path to an internal use case that would not require commercial hosting licensing through SPLA, particularly if the licensee owns the business logic, the content, or the data, and to deliver the service under its own brand. If you have that type of a situation, I think the best example of that is online banking. Then if you're a bank and you offer online banking, that doesn't run afoul of the commercial hosting prohibition, because the software is being used as a way to acquire goods or services from the licensee, in that example, financial services. And the bank is, if they don't own the online banking technology, they're marketing it under its own brand. And so for the most part, the online banking would be a pretty good example of an internal use case where you have third-party access. Another good example is the e-commerce platform. If you can envision an e-commerce platform hosted on Microsoft infrastructure where the business is to sell goods and services online, the hosting of the e-commerce website for purposes of the customer's ability to come on and place orders does not run afoul of the commercial hosting prohibition, because again, we're dealing with a third party accessing software as a way to acquire goods from the licensee. On that critical question number 5, you wind up with a yes answer. And so the yes answer leads you through to a point that says you can use internal use perpetual licenses from select or volume agreements or enterprise agreements, and provided that you cover the external use via an appropriate external connector license, then you can continue, if you have in the past, continue to use perpetual licenses without having to enter into the monthly reporting obligation of the service provider license agreement. The typical scenario where you don't answer yes to question 5, and the example that Microsoft provided in this particular roadmap, I think, is illustrative. Company A provides a customer relationship management application for Company B to support its customer engagements. If you're in the business of hosting Dynamics or even any other application where your customer is ostensibly paying you a fee related to infrastructure, hosting, licensing, and services related to that platform, that runs directly into the 4 corners of what commercial hosting is intended to cover, and would require, in most instances, a SPLA license. That, regardless of whether your business is IT oriented or not. So take a non-IT example. Company A sells a division to Company B. As part of that sales agreement, there's a transitional services agreement between Company A and Company B, where Company B, the newco, will be able to access the infrastructure of Company A. That is a very close cousin, even though you don't think of the business as a technology services business or a hosting company, that very well could run afoul of the prohibition on commercial hosting. So we're seeing not only our technology services clients struggling with these issues, but more and more our enterprise and mid-market clients that are not in the business of IT, that just through the nature of the way third parties are accessing their infrastructure, interacting with their company and the company's computer systems, and or because of M&A activity, wind up in a situation where they're dealing with these questions and need assistance in getting answers to how to avoid liability associated with these models. If you wind up with the answer on any of your use cases that you require commercial hosting rights and or that your current deployments run afoul of the prohibition on commercial hosting, you have two basic options. It's not commercial hosting requires SPLA. It's commercial hosting requires either SPLA or taking advantage of the self-hosted applications benefits that are included with software assurance. In the one scenario with SPLA, you're paying on a monthly basis, on a per SKU basis, and it floats up and down each month with a monthly reporting obligation. In the second example with self-hosted applications, all of the Microsoft infrastructure that is in question has to be licensed not only with the perpetual license, but also with software assurance under an enterprise agreement or other Microsoft volume license agreement. So there are no scenarios, for example, where you can do self-hosting without software assurance. So when you're doing an evaluation, and Christopher will walk you through how to do the math, when you're doing the evaluation between which of these plans is right for your use cases, you have to appreciate that both of them involve an ongoing cost in the form of either monthly subscription fees or ongoing software assurance that need to be factored in. In the service provider license agreement model, you're paying a fraction of the license, typically about 1/24th of the cost of the license each month. In the self-hosted arrangement, you've got a perpetual license that you've paid for with software assurance that pays on a recurring basis. But the initial acquisition of the software for the perpetual license would be a CapEx type of acquisition, where the software assurance would be OpEx. With SPLA, all of the licensing fees would be OpEx. And some of these accounting differences become very critical to evaluating which one works well. The other thing to think about is that with self-hosting rights, not the full suite of Microsoft products that would be available to you under a service provider license agreement do not carry the self-hosted application benefit as part of SA. So if you're thinking about self-hosting, you really need to make sure that your specific products in question qualify for the self-hosting benefit. And you see the note here, no mixing of license models is allowed. You're either in one or the other. You can have internal use perpetual licenses for your internally facing operations and a SPLA license. Those can coexist together. And you can have internal use and self-hosted applications, but what you can't have is SPLA and self-hosting together. It's an either-or proposition. So with that introduction and framework to the different options that you have, I'd like to turn it over to Christopher to do a deeper dive on how do you go about picking SPLA or self-hosting models.
All right, thank you, Rob. So as Rob already mentioned, the SPLA model is essentially a subscription model where companies that have signed the SPLA with Microsoft are required to measure their customers' usage of Microsoft products from month to month and then report and pay for that usage to an authorized SPLA reseller, which would be a third-party company like Insight or SHI that you would identify when you sign the SPLA. SPLA must be used in connection with software services that you offer to customers. It is not an alternative to internal use licensing. If you do not, if the products that you are making available or the products that you are wanting to license are not being used in connection with software services, ordinarily, SPLA would not be the correct answer for you. You need to look at a different license model. It requires that software services offering, and also there is a limit to the amount of internal use you can make of your hosted services. It is allowed for you to, for instance, using the CRM example, if you're making a CRM solution available to your customers, you are allowed to use that CRM solution for your own business operations, but there is a limit of usually about 50% of the per product usage level that you can make for internal use. So if that CRM solution takes or makes use of dynamics, the amount of the dynamics usage is attributable to your internal organization may be no more than 50% of the total dynamics usage in the environment. So if you have some type of an internal a solution that you developed internally over the years that you use for your internal business purposes, and you make the decision one day to start making that solution available to your customers, if that customer usage level is not going to result in an overall usage level that would keep you from running afoul of that 50% maximum, then you're going to need to look at spinning off that infrastructure to a dedicated hosting environment that you would be licensing under SPLA. Rather than trying to license the existing environment under SPLA. On the next two slides, we have some pricing examples that I've compared just based on a relatively small environment, hypothetical environment that's described there in the example paragraph. As Rob mentioned, the SPLA pricing is a fraction of what you would pay for perpetual licenses on the same product. And those fees, again, are paid on a monthly basis, usually as an operating expense. As you can see here, the little environment that I've hypothesized has Windows Server remote desktop services, and then SQL Server that are being used to deliver a hosted solution to end users. The fees per product that are in the example toward the bottom there are fees that appear on relatively recent price lists for SPLA products, and you can see how things total out there both on a monthly and a per year basis. Again, these numbers in terms of the annual cost, that assumes no growth. Most of our customers or most of our clients who have SPLAs are going to be adding to their infrastructure on a relatively regular basis, and or they're going to be adding users, hopefully, on a relatively regular basis in order to grow their business. So that annual cost, the monthly cost ends up increasing over the course of a year, and that annual cost would actually be greater than that. But just for the purpose of providing a simple example, I've not assumed any growth here. So this is SPLA. The products that I've selected results in this example at about a $55,000 annualized cost. So comparing that to the self-host model. First thing to keep in mind, again, the volume licensing costs for the perpetual licenses that you buy, those are going to be capital expenditures, whereas the renewal of software assurance following the initial term would usually be characterized as an operating expense. So in the example below, I've used the same assumptions regarding the nature of the environment and the products that are being used, and I have added in the perpetual license fees, which as you can see are considerably greater than SPLA monthly fees, as well as for certain products like Windows Server under SPLA. When you're licensing Windows Server, you're just counting up the number of processors for the infrastructure where Windows Server is deployed. Under perpetual licenses, you also have to purchase access licensing, either in the form of client access licenses, CALs, or for this example, for your external users, you would be purchasing external connector licenses and assigning them to your hosts. And you would need external connectors both for Windows Server and for remote desktop services. So that's why you see those new line items there. The first set of prices in the example represent what the amount you would pay for the initial term. So when you first set up your environment, you buy the licenses and you buy software assurance. That's going to end up being more since you're paying for the licenses with the software assurance, and you can see the total purchase amount for a 3-year software assurance term in this example would be about $270,000, and then you can just divide that by 3 to see what your annualized cost would be. If you're purchasing these licenses under something like an enterprise agreement, the amounts that you pay already would be annualized. There would be a total purchase amount for the 3-year term of the enrollment under the EA. So this would be more or less consistent with what we would expect to see in terms of the overall purchase amount and then how that translates on an annual basis. The second set of prices would represent what you would pay for years following that initial 3-year term. You wouldn't be buying or rebuying the licenses, but you would be having to renew software assurance for each of those licenses. So you can see the prices that are inserted for each product are substantially lower. Those are just the prices to renew software assurance. Again, this is something that could be characterized as an operating expense on your financial statements, and the total purchase amount for that subsequent 3-year term would end up being substantially lower since you're not buying the licenses. Again, though, you likely are going to be experiencing growth, both in terms of your infrastructure and in terms of the number of users accessing your products. The increase in users under this particular model likely would not by itself result in an increase of your costs, because everything that is presented here is licensed either on a processor or a core basis, and your external connectors are assigned to your physical hosts. So the number of users is kind of irrelevant, but you would be needing to expand the number of resources that you assign to your hosting environment more than likely if your user base is growing. So you would end up adding a license, licenses either during the true-ups under an EA during the initial 3-year term. You'd be required to report to Microsoft under an EA any increase in your license usage for products licensed under the EA each year. And then after that, and even if you're just renewing, this example just shows you renewing SA, but in most cases you would be buying additional licenses at the beginning of that subsequent 3-year term, so there more than likely would be additional licensing costs here too. So you can see comparing the prices we've got under SPLA, we had about $55,000 per year. Under the self-hosting model for the first 3-year term, it would be about $90,000 per year. And then subsequent, assuming, again, no license purchases after that first 3-year term, the SA renewable cost would be in the neighborhood of what you would be paying for SPLA. So the self-hosting model in many cases can end up representing a more significant financial commitment over an annualized period than SPLA can. And there's also a note here at the bottom with respect to Windows Server and RDS CALs. Everything in this self-hosting example is just geared toward what you would be paying for your external users to access the solution. If you want to use the products internally, you also would need to purchase CALs both for Windows Server and remote desktop services for your internal users, because the external connectors are only good to allow access by external users. So given the fact that self-hosting often ends up being a more significant financial investment, why would you select it? It's a good question, and there are some important advantages to keep in mind with respect to the self-hosting model. The first is that you only have the one agreement. You've already licensed the environment for internal use under an EA or a select agreement. You don't have to go out and sign another agreement with Microsoft that would potentially put you on a separate audit track under that other agreement, so that you'd be having to worry about getting audited both under the original volume license agreement and under your SPLA, which is a common fact pattern. Also, with self-hosting, there is no limit for internal use. So if you have that, in the example I discussed previously, if you have that CRM solution that you developed in-house and that you use in-house that you want to make available to your customers, you can start off slow as long as you satisfy all of the self-hosting requirements that we'll discuss in a minute and maintain software assurance on the licenses used to support those deployments. then you can have one customer the first month compared to everybody else being internal use case for that solution, and that would not run afoul of your agreement. Whereas under SPLA, as we discussed, you'd be having to contend with the fact that there's the 50% internal use limit for each product that you license under the SPLA. Another advantage for self-hosting is that there is no month-to-month auditing effectively required in order to confirm your usage. SPLA generally requires a more mature and robust internal software asset management practice, so that you have the ability on demand to obtain reporting regarding all of the usage of the Microsoft products that you're using for your hosted solutions and to accurately report that usage to your reseller. Many businesses just aren't set up to deliver that level of information on a month-to-month basis, and even if they think they're prepared to, they may not have the tools in place to actually deliver on it. So if you're not in the position of being able to do that, and you qualify for the self-hosting applications benefit, that second option represents a potential advantage in the form of a lower administrative burden associated with managing the program. It is still important to keep in mind, though, that just because you go with the self-hosted applications model, that doesn't relieve you of all licensing obligations. You still need to know what you're using. Under an EA, for example, you would be required to confirm that usage at least on an annual basis and submit an accurate true-up to Microsoft for any increased use, but you wouldn't be required to do that on a monthly basis. And then finally, another advantage of the self-hosting model is that in many cases, when you're audited under an EA or a select agreement, at least in our experience, the exposure that you see resulting from that audit in many cases is lower. The principal reason for that is that under SPLA, the audit exposure is not limited to what is discovered during the audit for the audit month. Microsoft's auditors will measure your current usage, and then they'll compare that usage against your current month to see if there's any shortfall for the current month. But then they'll also take a historical view and either use historical data if it's available regarding your software deployments, and in many cases it isn't available, or they will try to extrapolate your historical usage based on what you're using now and compare that to what you've reported to your reseller over the entire period that's within the scope of the audit, which can be 3 years or more. So that ends up being a pretty significant financial surprise for companies who may not have had the best software asset management procedures in place to track and measure their usage of Microsoft products. With respect to the hosting model, the historical view is largely out of the picture, and as long as the shortfalls, if any, that are discovered during the audit are associated with products that you've licensed under an enterprise agreement, those shortfalls can just, in most cases, be remedied with your next true-up. And you wouldn't face the sorts of penalties that you see under either the SPLA or other software audit models where a license purchase is required in order to resolve the audit findings. So self-hosting requirements, again, the self-hosting option is more expensive, but it offers some administrative benefits that might be valuable to you. So the next question is, how do I use it? As Rob mentioned, it's not available for all products, and it's not available for all use cases. If you look at the current product use rights document, and that is the set of license rules that Microsoft updates on about a quarterly basis and posts on its website, those license rules apply to products that are licensed under Microsoft's volume license programs, like enterprise agreements, select agreements, or open agreements. And if you turn to the, I think it's Appendix 2, at the back of the product use rights document, it describes all the benefits that you get when you sign up for software assurance. One of those benefits is the self-hosted applications benefit that we've been discussing. And there are 3 important points to keep in mind. First, the benefit is only available for certain products. When you look at the product-specific use terms for server products, they will have a little tag that says self-hosted applications, and it'll either say yes or no. This benefit is only available for the server products that say yes, and it's not available for any desktop applications like Office or Visio. So again, if you need to license those desktop applications or anything else that's not eligible for self-hosting, you would need to be looking at SPLA rather than the self-hosted benefit for your entire environment. Another requirement is sort of the obvious one that we've been discussing for self-hosting, is that you have to maintain software assurance coverage both for the licenses that allow you to install the software as well as for the licenses that allow your customers to access that software. So it would be the Windows Server Data Center plus the external connectors for Windows Server plus the external connectors for RDS. All of these things would need to be covered with software assurance. And then finally, there's a set of technical requirements. I say technical requirements. It's really more of architectural requirements that are highlighted numbers 1 through 4 on this excerpt from the product use rights that your solution must satisfy in order to constitute a, quote, unified solution that is eligible for the self-hosting benefits. And an important one to keep in mind, they're all important to keep in mind, but one that we often end up discussing with our clients is the fact that at number 4, the software that you bring to the table in delivering a unified solution to your customers must be software that you own. It can't be software that you license from another party and bake into the hosted offering. It needs to be something that you, if not developed in-house, that you have purchased and own and maintain in-house. Another issue that arises that Rob mentioned during the introductory remarks is that many of our customers or many of our clients will tell us, you know, we don't like SPLA, that sounds like a pain. We don't qualify for the self-hosting benefit, and or we don't want to pay for software assurance for our entire hosting environment. So what are our options? Can we have our customers absorb the costs associated with licensing Microsoft products and use their licenses to support those deployments on our servers? And the answer is yes, under 2 different options. Under the first option, you have a dedicated physical environment that you assign to a customer who is going to use its own licenses to support the deployments on those servers. Again, these are servers that the service provider owns, but they have been set aside and segregated from the rest of the hosting environment and dedicated to the exclusive use of the customer that wants to bring its own licenses to the table. This is an option that is allowed under the terms of the customer's license agreements with Microsoft. There is a section of the product use rights document called the Universal License Terms, and among those terms is a paragraph stating that this is allowed as long as that is a dedicated physical environment that no other customers are able to access. Under this scenario, the service provider doesn't have to buy any licenses at all. Everything that is required is something that the customer brings to the table. We typically advise our clients to require their customers to state in the customer agreement that they're going to be solely and exclusively responsible for licensing those Microsoft products, and that the service provider undertakes no responsibilities with respect to that licensing. But it's a relatively straightforward option, at least administratively. The stumbling block, of course, is the fact that it's an expensive option. If you're a service provider with hundreds of customers, in most cases you're not going to be able to afford to spin up a new physical hosting environment for each of those customers, and they want to bring their own licenses to the table. So for many service providers, it may be an unrealistic option. There is another one. Option 2 is license mobility under software assurance. License mobility is another benefit of software assurance, but this is a benefit that your customers would be taking advantage of rather than you. And license mobility is a term that Microsoft uses somewhat confusingly in several places within the product use rights to refer to different things. But in this example, the license mobility refers to using the customer's licenses in a multi-tenant environment. And there are a number of requirements here that I won't get into in too much detail, but it's a more complicated setup where the customer, again, has to maintain software assurance for all the licenses that they want to use to support deployments on the service provider servers. In addition, the service provider is required to have a SPLA, even though you're not reporting this particular usage under the SPLA. The service provider also is required to sign an amendment to the SPLA that designates the provider as an authorized mobility partner. There is a separate set of paperwork that the customer needs to sign, to fill out and sign, and then the service provider has to sign, and then Microsoft has to sign before returning the paperwork back to the service provider to be maintained in the event of an audit. So this is sort of the opposite in terms of administrative headache from the dedicated physical option, where you're having to jump through a whole bunch of hoops in order to make this happen for your customers. But it does have the benefit of being an option that allows you to set up your customers' self-licensed infrastructure in a multi-tenant architecture, so that you're not required to spin up new physical servers for each customer who wants to use their licenses in this way. It's our experience that in past audit matters that some of our clients who have attempted to use this option have failed to jump through one or more of the hoops that Microsoft has set up to take advantage of it, and it can result in unexpected exposure from the audit where companies thought that they were doing everything they needed to do but in fact weren't, and ended up being a negotiating point in order to resolve the audit. So the risks are definitely higher with this option, but it may be the only option if you are sure that you want to allow your customers to bring their own licenses and you don't want to deal with SPLA or self-hosting. So the next set of topics, as Rob mentioned, is going to pertain to SPLA policies and procedures and also to requirements for your customer agreements, and I will turn it over to Rob.
Thank you, Christopher. So this next section assumes that you have a SPLA and you're worried about your audit risks and you want to make sure that you set up the program in a way that you can easily manage it to be in compliance, and then when and if audited, be in a position to cover the types of data requests that will be made in that audit. A printed policy document that you work on the front end is what I've seen to be a very valuable tool to not only manage your SPLA environment, but to share with auditors at the inception of a scoping conversation. What it does is it tells the auditors that you're diligent and serious about compliance with the agreement, and that carefully explains to them what types of policies and procedures you have implemented to manage the environment. I'll give you an example. You know, I've worked on cases where clients were targets of SPLA audits, and I ask them basic questions about how they manage the environment, and the answers are loose. You know, I get a report emailed from so-and-so, and then I fill out the order with the reseller. Well, that doesn't inspire a great deal of confidence in the mind of an auditor who's trying to evaluate what is your methodology and how do I get comfortable on issues of completeness and accuracy. And so a detailed SPLA policy and procedure is very important. And the topics that are typically covered go from, you know, all the way from setting up new customers, how orders are made, how changes are made, how monitoring is done, what types of tools are going to be put in place, how frequently are we going to use them, and those types of issues can be laid out in a policy document in a way that would be very effective to help not only educate your team on what needs to happen, but also give you something to manage to ensure that you're on track. And not all of our SPLA clients' infrastructure is the same. In fact, we've seen a wide variety of use cases, from online grocery stores to cloud solutions providers to everything in between. And the policy document may need to be varied specifically to what your situation is and the relevant factors that may exist, including the number and type of products that are being used. For example, user-based products that are licensed per user or subscriber are to be managed with slightly different policies than products that are being licensed by processor or core. So there's different, the licensing metric will in many instances dictate what kind of tools and information you need to be gathering as part of your policy and procedure. For subscriber-based models, one of the issues that we get into all the time with clients is, what is a user? You know, how do I determine whether or not someone who didn't access last month should or shouldn't be counted as a user? You know, we've had clients that measure their users by looking at those that actually accessed in the prior 30 days and use that number to true up. Well, that number may or may not be accurate, but it's definitely not tied to the relevant licensing metric, which is authorized to access your instances of the server software directly or indirectly, regardless of actual access of the server software. That's what use means. So you've taken a term that has a common use and meaning, and you've redefined it not to mean use, but to mean those that could use. And you have to count your subscribers in a SPLA environment in that way. And why does it become difficult? Well, if you authorize a lot of users, for example, you've got a human resources portal, and you've got thousands of users authorized to get on that portal, but they only come on, you know, once a year each. Well, you would need to buy a subscriber access license for all of those users, because each is still authorized to access. And so aligning the number of those that are actually using with those that are authorized to use is the key to managing your SPLA environment. In fact, effectively, and how we do that is through implementing policies and procedures around managing your Active Directory, making it very clear which users are authorized to access which applications, and then managing those lists so that those that are inactive for a period of time become disabled automatically. That way you don't have a runaway problem with those that are authorized to access. And what we have found is that when it comes to managing users in a SPLA environment, it requires a much higher degree of Active Directory maintenance and management and updating than what the typical client would otherwise do absent this definition for managing subscriber access licensing. So in many cases, our clients will set up their SPLA environments to avoid subscriber-based products. So if there's an option to do it either on a processor or server basis or core basis versus a subscriber basis, many will choose not to be in the business of counting users because of this particular concern. Christopher talked about the policies on customers bringing their own licenses. Your specific policies and procedures around BYOL should be included in your policy statement. We talked a little bit about Active Directory hygiene, which is the next slide. I can't emphasize for you enough how often Active Directory data is being used in Microsoft audits by Microsoft's auditors to create a universe of your environment that is broader than what is actually there, and putting the burden on you to explain away the objects that are no longer in use, that have been decommissioned, the users that you claim are no longer accessing, and getting ahead of that through implementing policies and procedures designed to actively manage your Active Directory are critically important. And what I always like to do is explain to my customer, look, a user is not authorized to access. If we attempt to log on as that user and pass their credentials and we can't get in, that's conclusive evidence in an audit that that user is not authorized to access. So setting up your security policies, your organizational units within Active Directory to programmatically include and exclude users who are authorized to access specific applications is the key to being successful in this area. One of the things we talked about is alignment of the actual usage to the those that are authorized, and the way that you do that is you manage the inactives, those that don't log in for a period of time. 30 days, 60 days, 90 days, become disabled. Not deleted, just disabled. They could open a trouble ticket and say, my password's not working, and you'd open a new trouble ticket for them, and you'd re-add them to those that are authorized. But managing it in this way, it avoids the problem where you've got a huge disparity between those that are authorized and those that access. And that disparity is the source of significant legal liability in connection with SPLA audits that these policies and procedures would be designed to avoid. One of the issues that comes up quite frequently in SPLA audits is there's a audit that's done for the current month, and there are findings of compliance gaps for that month. And then because of the language in the SPLA, in the NBSA, that allows the auditors to extrapolate findings, usually creates a situation where the largest issue in a SPLA audit on terms of financial matters with Microsoft turns on this historical look-back period. So rarely does the customer fight about, oh, I had a gap, it was X thousand this month, I've got to true it up, and I've got to true it up that way going forward. Most clients don't have any qualms about that. Where the disputes arise is where Microsoft's auditors take that gap, and let's say it's a $5,000 gap, and then want to extrapolate that backwards for 3 years. So a $5,000 gap now becomes a $180,000 backwards-looking demand. And that's where a lot of the disputes arise in connection with the ability to resolve a SPLA audit. So typically, what we're dealing with is this backwards extrapolation of findings that almost always yields a very unfavorable license position and can, in certain cases, lead to very large financial demands from Microsoft after the auditors have concluded their calculations. The best defense against that outcome is to implement policies that require all monthly SPLA to be saved to an archive that can be accessed easily in the event of an audit. So in the look back, Microsoft has the right to extrapolate, but you have the ability to come forward with rebuttal evidence that shows that the relationship of a particular customer or that the overall environment was different during those prior month periods than they were than what is being depicted in the audit. Where clients get into trouble, however, is that they don't have that historical data, and therefore it becomes difficult to rebut the extrapolation by the auditors because the data was not preserved. And so when we set up policies and procedures for managing SPLA, each month we capture enough information and put it in the file with the order so that if anyone wanted to come back and audit that particular month, that we would have an audit trail to avoid significant exposure due to backward-looking extrapolation. We also mentioned to you that many of our SPLA customers don't realize that Section 8 of the typical SPLA agreement has minimum required terms that must be included in the end-user agreement. You can see them listed here. Many of them are mutually beneficial to the service provider and to Microsoft. There's certainly no harm in including these in most customer agreements, and we work with many clients to incorporate these requirements into their customer-facing contracts to be in compliance with this Section 8. So the other things to think about on the end-user licensing terms, if a service provider also will be distributing client software in connection with hosted solutions, for example, Outlook with Exchange plus subscriber access licenses, then the service provider also must include end-user license terms with its customer agreements. And end-user license terms are included as an attachment to the SPLA and may be attached to and incorporated by reference into a customer agreement. You know, I think that this is a requirement that a large number of people who are in SPLA and who are considering SPLA have overlooked in terms of this requirement with end-user license terms, and it's something obviously that you want to bake into your policies and procedures to make sure that you're in compliance to the extent that you're distributing Outlook and other products that require an end-user license term to be included, that you are in fact doing that. With that said, I'd like to turn it over to Christopher for the balance of the time to share with you some tools that we recommend that you use to manage your SPLA environment. These are tools that would hold up in an audit situation. In fact, in many instances are the very same tools that auditors are using in active and live SPLA audit matters that are ongoing now.
All right, thank you, Rob. So regardless of the specific tools that you use from month to month, they're in most cases, in our experience, and we've helped many clients at this stage to analyze their data both in the context of preparing for SPLA, managing SPLA, dealing with SPLA disputes and audits. And there are, in most cases, 4 sets of data that are going to be relevant to these questions, or that are going to be things that you need to be prepared to collect both on a monthly basis and in the event of any license review by Microsoft. The first would be an inventory of the servers that you use to deliver your software services, and that's usually going to be just a hardware inventory, although in many cases it also will include information about the Microsoft Windows Server operating system that's running on those servers. The next set of data would be an inventory of the Microsoft software products that are deployed on those servers above and beyond Windows servers, so SQL Server, Exchange, Office, if that's something that's part of your product set. You also would need to be able to capture information about optional functionality that might be enabled on those servers. So for example, SharePoint or Exchange have enterprise-level functionality that require additive licenses above and beyond the standard access licenses. You need to know if those functionalities have been enabled. The third set of data would be if you are running a virtualized environment, and most service providers are, you need to be able to map your VMs to the hosts, the blades or other physical hosts where those VMs are deployed, and also need to be able to identify any high availability clusters where those hosts might be configured. You also want to be able to capture information about the number of physical processors and physical cores that are activated on each of those hosts, so that you can make an informed decision about whether you need to license the Microsoft products either based on the VM processor resources or based on the host processor resources. And then finally, if you are licensing products by subscriber access licenses, you need to be able to gather information from Active Directory identifying all of the users with access to those products. We also often see Active Directory reporting used as a way to validate the completeness of a hardware inventory. In the event of an audit, this would not be optional. Microsoft's auditors will want to see another data set to confirm that whatever inventory information you provided from another source is complete. But if you're not reporting any Microsoft products under SPLA on a user license basis, then the Active Directory user reporting might be optional for you on a month-to-month basis. So what are the tools that you use to gather those 4 bits of information? The inventory, both with respect to hardware and software, can be gathered using a free tool that Microsoft makes available called the Microsoft Assessment and Planning Toolkit. Again, that's a free tool that Microsoft makes available on its website, and it provides relatively robust reporting for most Microsoft products that you would be making available to your customers. It does have a few weaknesses. If it's the first time that you've deployed it and you haven't configured it and your user license products to capture usage information about how many people are actually authorized to access those products, then it doesn't really provide that information in an instant. You need to have it configured to set that up prospectively. It also has poor native reporting for certain desktop applications like Office that might be installed on your servers, although there is a way to query the map database directly to get that information. And it also doesn't, I say no useful information regarding virtualization. There is virtualization reporting available in Map Toolkit, but in my opinion, it's not really the best reporting for these purposes. For that, if you're running a VMware environment, and some people aren't, but most of our clients I would say are, there is a free tool called VTool, which takes advantage of the VMware Infrastructure SDK to display and report on a wide range of information about your virtualization environment, more really than you would need for purposes of the audit, but it certainly gets you what you would need in terms of your reporting obligations under SPLA, and I've provided a link in the slides for you to go to the developer's website and review the documentation about that tool. And then finally, to query Active Directory, there is a command line utility that's included with Windows Server called CSVDE. It allows you to gather, again, a wider range of information than you may need for SPLA purposes, but you can configure the query to capture information that would be relevant to your particular use cases. And I've provided a sample query here that would provide a set of users that you would need to be prepared to count. That is a standard query that we see in many Microsoft audits under SPLA, and then there are other volume license agreements. And that concludes my remarks. Rob, did you have any concluding remarks?
Yes, thank you very much, Christopher. Wanted to let everybody know that if you ask questions, we'll take your questions offline and reach out to you either via email or telephone. And if you have additional information that you want to share with us or you want to make contact with us, our contact information is listed here on this last slide. Or you could feel free to call the office at 214-999-0080. Thank you, everybody, very much for attending.
And then if you are interested in